today's video, we discuss 3 top legal strategies for medical spa compliance. I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We help healthcare industry clients navigate healthcare and FDA legal issues and launch or continue to scale their health and wellness product success. Let's say a registered nurse and an orthopedic surgeon came together to talk about having the orthopedic surgeon come aboard as medical director for the RN's existing medical spa. They wanted to do Botox parties, and they had an informal arrangement where the surgeon would rent a room in the spa and have some business cards printed up that said medical director for the surgeon. Does this kind of arrangement sound like one that you might take or be contemplating? Does it entail legal risks? We have 3 tips for you today, legal strategies that potentially could pay off in terms of lowering your overall compliance risk. So first of all, the term medical director is used a lot. Yet the California Medical Board has pointed out that if a registered nurse, physician assistant, or someone like a business person, the serial entrepreneur, tries to hire a medical doctor and call them medical director, this is an arrangement that essentially is rent a license. The board might cry corporate practice of medicine and find the arrangement unlawful. We actually discourage the notion of a medical director because a medical director should not be directing anything or anyone other than his or her own clinical staff. And in the arrangement we describe, the registered nurse is really meant to be the one calling the shots, getting the patients and creating a scenario where the orthopedic surgeon is there in name only, collecting a check for letting them attach their credentials to the enterprise, at least the way we're conceptualizing it here. Now, the second tip, when a healthcare licensee, like a medical doctor, rents space, the arrangement should be at fair market value. It must not fluctuate by the value or volume of referrals. In practice, this means that hourly rentals suggest a payment that does go up and down with the number of patients, like every hour, and thus violates state law prohibitions against kickbacks and fee splitting. We have a lot more detail on this argument, this concept on our blog, cohenhealthcarelaw.com/blog, so the video is a quick lightning round. Third, in this scenario, the registered nurse could create an MSO that runs the medical spa business. It might do administration or management and marketing. The MSO can charge the orthopedic surgeon or the professional corporation at fair market value for services involving management and marketing. So this requires creating an MSO, having an agreement between the MSO and the surgeon or their professional corporation or PLLC, and then doing what MSOs do and getting paid for services in this rational way. Now, this is different than having the nurse call the shots, hire the doctor, and it's not a partnership between the 2 clinicians. There are lots of variations, for example, lots of issues. For example, do you need a good faith exam? Who does the good faith exam if you need one? What about doctor supervision of the nurse? Is a collaborative arrangement necessary, and if necessary, is it enough? Well, if you're interested in an early read on your business that gets deeper into the issues than we can in a short lightning video, we encourage you to book a legal strategy session with a member of our legal team. And we describe the legal strategy session on our website, cohenhealthcarelaw.com. Thanks for watching. If you still have questions, click on the link below, cohenhealthcarelaw.com/contact, to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.